of curfew in the end of the day. And beside this, we will have a dinner at 9 p.m., which will be served on the second floor of this hotel. So, that's it. And the next panel, ladies and gentlemen, the next panel is about Web of Accountability for International Crimes. And we have several panelists. They are Ladislav Homron, President of Eurojust, Christos Jamopoulos. Thank you very much, sir. It was really hard to say. Sorry about that. Director General of Human Rights of Rule of Law, Council of Europe. Sir Howard Andrew Clive Morrison, Judge of the International Criminal Court based in The Hague. So, ladies and gentlemen, I'm kindly asking all panelists to take their places.
Четвертий. Останній стіл. Останній.
So, Ladislav Homron.
Раз.
Christos Giacomoulopoulos. Sir Howard Andrew Clive Morrison, please. We are waiting for you. We need to go further.
Ви не модератор, ви спікер. Це
We have some technical issues to resolve, and I think we're pretty much ready. So, ladies and gentlemen, I'm kindly asking you to take your places. So the moderator of this panel is Eka Tkeshalashvili, Chief of Party of the USAID funded support to anti-corruption champion institution in Ukraine. And she's somewhere around, so we are waiting. So we are waiting for the Eka, yeah?
No, I'm here.
Oh, you're here. I'm sorry. Oh, yeah. Ladies and gentlemen, please take your seats. Our panelists are ready, so we are ready to continue.
Well, it's working, right? Yeah. I'm sorry. Can we ask for the doors to be shut maybe because it's too much noise, and then we can start. Well, good evening and warm welcome, ladies and gentlemen. It's a lot that we had to take in, obviously, emotionally, in terms of information as well, with the opening session. And I hope that you could bear with us now with the panel discussion that proceeds right after lengthy but very tense, emotional, and informative opening session, I would say, which was not usual one that you could see maybe in some of the conferences when it's just formal openings, but it was quite emotional for many of us as well to listen to all of it that we had to take in, and then quite informative, I would say, in terms of taking stock of the developments in this direction. What we will try to do with an excellent panel that we have now today with us, that brings not only wealth of experience, but then quite proactive engagement in the real processes that are ongoing right now in viewing that web of accountability that we will be talking for the couple of days now ahead of us, is that to perhaps dig deeper on some of the aspects that have been already mentioned during the opening session, and to perhaps highlight more what are the challenges that we face on that road and pathway, quest, as the minister mentioned it today, and then what will it take for us to do more and perhaps to do better, to have that ultimate goal of justice being served being something that could be achievable in a shorter period of time rather than becoming an intergenerational task as it could have been previously in other war-related situations. I have to say that in this part of the world, and I come from Georgia myself, we bear witness to Russian atrocities for decades. So when we listen now and bear witness to what is happening at an atrocious scale in Ukraine, deep down, we don't have that much of a shock that is possible that otherwise, in normal circumstances, we all could have had. For far too long, Russia enjoyed impunity for crimes of various scale, but crimes that could be easily defined as atrocities in countries neighboring to Russia, my own country, Ukraine, not only now, but starting back then from 2014 and 15, and Moldova, Syria, Mali, you can name it. And then today, President of Latvia went even way back identifying crimes committed by Soviet Russia, as we call it in this part of the world, rather than USSR, and atrocities and crimes that have never been neither prosecuted or properly accounted for. And by properly accounted for, I mean defined, at least, as crimes that deserve to be defined as they were at that time and then in the recent history as well. So when we speak now about web of accountability, and I guess before we go to that process of discussing mechanisms, institutions, actions that are undertaken now or should be undertaken in the future, I would like to take a moment of reflection from the panelists perhaps, and then to give your account of why it matters so that accountability is actually guaranteed. From the perspective of the current war in Ukraine, that brutality that we witness, that continues to be inflicted upon Ukrainian people now, and it has never stopped actually, but rather increased from the Russian side. So why should we need to be reassuring not only Ukrainian public, but then the whole civilized world that rules matter, and then accountability is something that one can count for, and with that, perhaps the rule of law could prevent and deter the crimes in the future to be committed. So, Sir Howard, I'll start with you. You're next to me, right, in proximity.
Well, hello everybody. First of all, can I just amend my introduction? I'm no longer a judge of the International Criminal Court. I was until April of 2021. Since then, I've been appointed as the UK independent advisor to the Ukrainian Prosecutor General, and I've undertaken the task of training judges, particularly Ukrainian judges. How do we start? Any student of criminology will tell you that until someone who commits crimes is caught and brought to justice, whether it's on the domestic stage or the international stage, they will carry on committing crimes. What stops people from committing crimes is being brought to proper justice and perhaps receiving a custodial sentence. The lifeblood of any prosecution of any case is evidence. Without evidence, you are going nowhere. I, for 2 decades, as a defense counsel at the Yugoslav and Rwanda Genocide Tribunal, and then as a judge at the Yugoslav Tribunal, and then as an appeal judge at the International Criminal Court, I heard an abundance of evidence which I hoped I would never hear the like of again. Some of it was the most awful things you could ever hear. I recall Srebrenica in particular, when 7,000 Muslim men and boys were butchered and buried in mass graves, which were then dug up and they were reburied. They didn't even leave them any dignity in death. But I fear that lawyers and judges and the global public are going to hear accounts of that sort of evidence all over again. And it's even more important, if we didn't stop it before, that we stop it now. Don't just owe it to the people of Ukraine, but of course how much we owe it, but we owe it to the generations to come. Now, prosecuting war crimes, well, prosecuting domestic crimes is difficult. The prosecutor has upon him 2 burdens. First of all, the burden of proving the case, but not only that, the prosecutor has to prove it beyond a reasonable doubt. It's a high burden, a high bar. And so what any prosecutor needs, whether she or he is dealing with a domestic court or an international court, is relevant, admissible evidence that meets the case. So they rely heavily upon professional investigators to go out into the field and accumulate that evidence. There's no point in just finding it. You've got to analyze it, you've got to record it, you've got to store it, you have to set up a chain of custody. If it's biological forensic evidence, you have to preserve it. All of these things are hard enough in themselves. Then you take that evidence as an investigator to the prosecutor, and he or she has to analyze it and decide whether or not there is sufficient evidence to bring a case. And if so, what is the case to be brought? Is it a crime against humanity? Is it a war crime? If so, what's the nature of that crime? Rape, murder, torture, deportation, or all of the above? And that's a hard job in itself. But then, what does the prosecutor have to do? It has to disclose all of that evidence, both inculpatory and exculpatory, to the defense. That's how you run a fair trial. A prosecutor does not want and should not want a conviction at any price. What a prosecutor wants to do is to be himself or herself a minister of justice, to make sure that the accused person, who is innocent until proved guilty, receiving a fair trial. Now, some people have asked me, well, will Russia be taken to court? And the answer is no. International criminal and humanitarian law doesn't deal with states. It deals with individuals. It deals with individual criminal responsibility. So what you have to do is to collate the evidence which is pertinent to that individual or those individuals, if it's a multi-handed trial, and put it before the judges. And then the judges have the onerous task, and believe me, it can be an onerous task, of sifting through all the evidence that they hear before producing a judgment. And in the case of Karadzic, that took us well over 4 years because of the mountains of evidence that we had to deal with. All of this is a long and painstaking progress. But if in Ukraine you don't start now, then you lose the momentum, which is why everything we're hearing about today is so vital and so important. Whether it's trying domestic crimes, and the International Criminal Court gives primacy to domestic jurisdiction under the principle of complementarity. It doesn't replace domestic courts. It deals with the cases that those courts either can't or won't deal with. And it will only deal with the most egregious of cases. It's only going to deal with the most senior of political or military figures. And then we've got the other mechanisms, such as universal jurisdiction, which some countries are taking very much into account, and that's a powerful tool. And then we have this concept of a separate tribunal to deal with the crime of aggression, because as a result of Article 15 of the Rome Statute, the ICC is not empowered to be tried in try Russia in the ICC. It does, however, have a mandate for Ukraine, because Ukraine voluntarily submitted to the jurisdiction of the ICC in 2014 and then extended it indefinitely under Article 12 of the Rome Statute. So all the powers, all the mandates, all the possibilities are there. What we need now is the collective effort and courage to pursue this to the end, wherever that end might be. I don't know where the end is, but I do know where the beginning is. The beginning is today. Thank you.
Very short follow-up question to you, Sir Howard. Would you think that if the crime of aggression is not covered by the web of accountability as we have it now, that accountability ultimately would be ensured, or that gap is too much to bear?
Under the Ukrainian Criminal Code, you can try the crime of aggression. You can also try people in absentia. Now, trials in absentia are second best, but they're better than no trial at all. All of the trials at the Special Tribunal for Lebanon were trials in absentia. Why? Because that tribunal utilized Lebanese law, which allowed for it. And so if you have some sort of tribunal, whether it's called a hybrid or it doesn't matter, it's got to be a tribunal with effective powers to try the crime of aggression and perhaps face the reality that they may have to try some people in absentia.
And I would assume, obviously, that any tribunal of that kind should have the right to prosecute the heads of the states, and then not to have the hurdle of not being able to overcome the state immunities or the personal immunities in this case. But
Just one quick comment. If it's an internationalized court, there's no immunity.
Absolutely. But I meant more for the Ukrainian court in this case. Mr. Harman, if you wish to continue perhaps on that question as well when it comes to why impunity, breaking cycle of impunity matters now. And then if you could give us a bit of a stock taking of where do you feel already you are in your position already, putting the mechanisms and processes at place that helps Ukraine actually, and other countries that are helping Ukraine to actually put this process in the shaped, mainstreamed manner that actually allows to gather evidence, to identify perpetrators, and then prepare for the effective prosecution in the future.
Thank you so much. Actually, why we have to ensure accountability, I will use the words of the President Zelensky, because I believe that it's our moral and legal duty. And I also believe that we have to do it for humanity and for justice. Now, I would like to then make a bridge and go to those practical examples. As I was mentioned, Eurojust has been supporting the joint investigation team from the very beginning. The joint investigation team was set up just a few weeks after the invasion of Ukraine, and since then we have been supporting the joint investigation team financially, legally, by our expertise, we logistically, and also we managed to create for them a secure communication network for communication and exchange of evidence. We also realized that we have to be more innovative and creative, as it was mentioned that always these crisis situations offer and also an opportunity, and we realized that Eurojust there are two important aspects, and one is when I was soon after the invasion with then Prosecutor General of Ukraine, Ms. Venediktova, the situation was very uncertain. Even Ukrainians didn't know whether they will be able to defend their sovereignty and independence, and if yes, for how long. So the question was that they already had many documented war crimes, and the question was, can Eurojust actually make sure that this evidence already collected can be stored safely outside of Ukraine to ensure that there will be a follow-up, and perhaps countries using principle of universal jurisdiction will make sure that there are investigations perhaps outside of the Ukraine, however, and run by different authorities, however, to ensure that war criminals don't leave the stage unpunished. The second element for establishing core international crime evidence was the fact that we have now very fragmented operational landscape. We have many judicial and law enforcement authorities interviewing refugees, taking witness testimonies of those who reside outside of Ukraine. And we have now also unprecedented amount of digital evidence, which is either taken by those refugees, witnesses, or relatives of refugees who are still in Ukraine in war zones. Plus, of course, we have a myriad of evidence which is now on social media and so on. So this was a big challenge actually and is a big challenge for every prosecutor, because if you have a digital evidence on social, or you have a video footage on social media, this video is not automatically considered as evidence. So you as prosecutor, you have to analyze it, you have to check whether it's fake, whether it was altered or not, whether it's genuine. You have to locate it, identify the location, and so on. You also have to actually make a decision, prosecutorial decision, what actually, what we see, what is actually, it is legally. What crime we see, or what crimes we see. And some acts usually can be legally qualified by 2, 3, 4, 5 in different ways. And we at Eurojust, we decided that we will help countries with this legal analytical part, and we will also bring the fragmented evidentiary landscape to a centralized, and we will help them, also Ukrainians, but any other countries, to make sure that we have a database which is actually centralizing all these international accountability efforts. We also see that operationally what is happening, that countries which do not have universal jurisdiction, however, they have victims in Ukraine, and they started their investigation, and they are searching for evidence. So they are sending different letters of request and doing kind of fishing expedition. A kind of remedy to this will be, hopefully, if countries will contribute to core international crime evidence database, that there is no need for a fishing expedition. Simply, they ask Eurojust, is there or which countries have evidence concerning this particular incident which happened in this location during this period of time, and is there available evidence? And if you consult the database, then we will be able to tell them that different pieces of information or pieces of evidence are in Poland, Lithuania, Slovakia, Portugal, US. And then they have to, instead of fishing expedition, they can start with legal procedures and request these pieces of evidence from those jurisdictions. This evidence database with also other advantages. We would like to avoid the kind of Sunday football school approach that here is the ball and everyone is running after the ball. We would like to ensure actually that we have clarity who is investigating what. And if we see that 3-4 countries are investigating and collecting evidence concerning the same incident, perhaps it might be good to sit down and to agree who is going to investigate. This will lead to more effective resources, use of resources. This may lead to more effective investigations. This will lead to simply better results. So this is, in a nutshell, the idea behind the Core International Crime Evidence Database. We had different questions related to big data. I would like to emphasize that Eurojust is not there to analyze every single video which is available. We are not there to actually analyze all the big data which is now available. We would like to really focus on those pieces of evidence which are actually considered by judicial authorities as relevant pieces of information, evidence actually proving core international crimes and what kind of core international crimes. Few words about the ICPA, the International Center for the Prosecution of the Crime of Aggression. The idea behind this is very simple. We as judicial authorities, we see that we have already so much evidence that it's not anymore enough just to meet occasionally and to discuss coordinating mechanisms or coordinative activities. We believe that there is a time and room to step up the investigative efforts, and we have to connect prosecutors, investigators working on these crimes in one place and create even more tighter connections than to meet on ad hoc basis once per month. So we will ensure that actually prosecutors from countries who have investigations into the crime of aggression, today we are aware of 5 those countries, that they can second their experts and they can work closely together, and they can also benefit from international experience and expertise, and also analytical support, legal support provided by Eurojust. So we believe that the discussions on the establishment of the tribunal can go in parallel, but we should not waste time, and we as prosecutors, we should start collecting evidence, and not only collecting, but really building up a file, whether for a tribunal, whether internationalized, hybrid, or whatever shape it will have. So this is from our side. Thank you.
Would you think perhaps that the work of the center could indirectly contribute to broadening the acceptance of an idea of creation of a tribunal among the countries that are not supporting now, so that the evidence or collective data and analysis, I understand that it's an internal work, more on an operational level, but would that be of use perhaps in communication then that diplomats could use in terms of substantiating the crime of aggression as it is, and then the need of creation of the tribunal with overwhelming evidence that could be supportive of those arguments?
Thank you, I understand, but I'm a prosecutor. I don't want to speculate. These decisions to establish a tribunal, and if yes, in what shape, these are political decisions and political debates. We are, of course, from our point of view, legal point of view, prosecutorial point of view, professional point of view, ready to share our experience. We believe, as I said, it's time to start building up the file for a court. Let's keep it in this way. Thank you.
Thank you. Dear Director General, it's your turn to reflect, if you wish, on the question related to why it is important for us to ensure accountability. And then obviously there is a lot that from the Council of Europe's perspective you could tell to the audience. We've seen numerous resolutions of the Parliamentary Assembly, decision of the Ministers' Committee. So your Council of Europe stands firm in terms of its position on what needs to be done and then how accountability should be assured. But it would be very good to hear more of what it means when it comes to the actual activities of the organization, and perhaps to see this as a moment for Council of Europe to revalidate its role in so many ways of being at the forefront of defense of human rights and values of freedom and dignity for which the organization obviously has been created for.
Yes, thank you very much, Eka. Your first question is quite important, actually. It says, why is accountability important? For lawyers, this is obvious, because the rules matter, actually, and that's why we need to have accountability. And I believe that the same should be for politicians, because unless you have a very pessimistic approach of history, wars end with peace, and you cannot have peace without justice. So these two elements, I think, are converging to all the accountability efforts that the international community is in now, united for justice, as we say. I would like to also say that the accountability issue has many aspects. The most important of them is, of course, the criminal accountability, but there are also others. I mean, the president of Latvia referred, for instance, to the accountability of Russia as a state for its international obligations, and there may be also aspects of reparation, of liability for redress, which may be or may not be connected to a criminal conviction. And I don't dare to go into so much into the criminal aspects, because with Sir Howard and Ladislav Harman here, I will perhaps concentrate on the others. So I would just like to say that from the outset, within hours after the full-fledged aggression on Ukraine, Russia has been suspended and then within weeks expelled from the Council of Europe. I think that this is also an aspect of the accountability of the state for violating not human rights, and we will come to that, but the statute of the Council of Europe, simply an international obligation to be part of a family. Now, President Levits said that there is a role for the European Court of Human Rights, and there is, of course, a role for the European Court of Human Rights, because Russia continued to be bound by the European Convention of Human Rights until the 16th of September. So an important part of the aggression and of the war that started on the 24th of February is covered by the responsibilities, the obligations that the Russian Federation had under the convention. And there are cases pending, several interstate applications by Ukraine, in particular the Ukraine versus Russia number 10, which relates actually to human rights violations that have taken place since the 24th of February. And also some 8,500 individual applications that relate to human rights violations. So all this will come with perhaps a finding of a violation, with a judgment which is binding, and I think the European Court of Human Rights, perhaps together with the International Court of Justice on the genocide issue, are the only international courts that are competent to deal with the aggression as a state issue, and possibly also with an award of just satisfaction, as we say it, which is an award of compensation. So this could also come as a part of the redress aspect that I have referred to before. Now, on the criminal aspect, the criminal accountability, as Sir Howard has said, I mean, this is mainly a competence of the Ukrainian courts. And as you have heard today from the Prosecutor General, and I see the President of the Supreme Court of Ukraine also present here, there are some like more than 60, 70,000 cases. Dealing with these cases is a huge task for the prosecutor and for the Ukrainian judiciary. And the Council of Europe does not deal with these cases, but offers assistance from the very outset. I mean, the first meeting that we had with the Prosecutor General was at the beginning of March, or mid-March already, 2022, with Irina Venediktova, not so far from Lviv, by the way. And the assistance that we offer is not of the kind that Eurojust or the Joint Investigation Team offers, but an assistance, and I think we will have the opportunity to discuss it during the next panel, of which is based on the human rights obligations of Ukraine. Because contrary to what Russia has done, Ukraine is bound by the European Convention of Human Rights and will implement the European Convention of Human Rights during the war. And this is an incredible and very strong signal of what this war is about. It's a war also about values. And this is what is so important. What are the obligations of the Ukrainian law enforcement agencies, to put them all together? First, an obligation towards the victims to investigate effectively. To investigate effectively into deaths, to investigate effectively into torture, into ill treatment. And then, fairness, to investigate fairly. And this is an obligation against the accused, towards the accused. So the task is huge, as I'm saying, and there is an enormous need for all of us to provide assistance in any form to Ukraine. And that's why the Council of Europe from the outset was very much in favor of this dialogue group. Since the meeting in The Hague on the 14th of July, we are part of this, of the institutions that are part of the dialogue group, and we are very happy to see that it takes place today. Let me come very shortly to the liability for reparations, because I think that there the Council of Europe can also have, I mean, the Secretary General, our Secretary General, Maria Pecinovic-Buric, said that the Council of Europe can have a leading role there. Let me stress once again, we are talking about damages caused by the war of aggression, and this irrespective of whether you have a criminal conviction or not. Of course, many will depend on the criminal conviction, but sometimes you will not reach necessarily the person with individual criminal responsibility. But this does not mean that there is no liability of the state. So I think that both the Committee of Ministers and the Parliamentary Assembly of the Council of Europe recognize that there is a need to engage in this field. And as a first step, at the request of our Ukrainian authorities, to go for this register of damage. We are in touch both with the Ukrainian authorities, and I hope that this will be clarified very soon, how to go about this register. Also with the Netherlands and the authorities of the Netherlands, because for obvious reasons of practicalities, this register should be placed in The Hague because of the connection with Eurojust, with the connection with the ICC. So I believe that member states of the Council of Europe are ready to take the lead together with the European Union, together with other non-member states of the Council of Europe who would like to join. And I think that this is one of the important aspects. We can act rapidly, and I think the speediness is important because it's a responsibility towards the victims. So I will stop here. Thank you very much.
We just wanted to specify, perhaps, with the question that there are two dimensions, right? When we speak about the reparations or the damages that are inflicted, it's the damages on a micro level when it comes to the immense level of destruction of a country, and individual victims that need to be compensated as victims of those crimes. So one would hope that when we speak about the financial aspect of accountability, there is a possibility as a mechanism that could allow for some of the assets that are frozen now, including Russian state assets, that could be used for the good cause of reconstruction and rebuilding of Ukraine as well, somewhat in the near future, rather than waiting until the war even ends in that case, if it comes to the fast recovery. But I understand these are the difficult legal questions, but in the comprehensive way of looking on what accountability means, financial element is a component that cannot be overlooked. I completely agree with you on that. I just wanted to give you a small quote of Nobel Peace Laureate Alexandra Matviichuk. When she spoke about the importance of accountability for Ukrainian people, and it really stuck with me. She described that she started to collect information about the war crimes and atrocities, because for Ukraine it was war crimes already when Crimea, Tatars were being persecuted in Crimea, and when in the occupied regions of Luhansk and Donetsk as well, Russia was committing atrocities. And then at the time, she could narrate the stories because her stories had the names, families. It was a number that was manageable for her to hold as a story narration. And then with the war, it became statistics because the sheer number is incomprehensible already. And then the way she describes that is that the justice and accountability is needed to bring back the names and faces to the people that have suffered through these brutal atrocities. And on the other hand, definitely to put the names and faces of those who committed and abetted and perpetrated, so to say, those crimes as well. So the deeper meaning of what accountability means for Ukraine is just cannot be overestimated. This very meeting has been hailed by the local media as a Rammstein of justice, and that tells in itself how much meaning people, ordinary people, give to this meeting that is dedicated to accountability, not to weapons directly, not how to win the war on the physical battlefield, but how to win and be victorious on the legal battlefield for Ukraine. You want it? Yeah, sure.
I just wanted to mention two things that occurred to me. Everybody, the date of the 24th of February, of course, resonates with everybody. Actually, the date of the 21st of February of 2022 resonates with me as well. Why so? Because on that night, Putin addressed the Russian people on television, and he went out of his way to vilify the Ukrainian judiciary and the nascent drive on anti-corruption. Why would he do that? Was that simply irrational bile? I think there's a dark rationality about it. He knows that the thing he doesn't want to come across the border like some form of COVID is the rule of law and genuine judicial independence, because the Russian state cannot cope with those. And I think that's why he said what he said. The second thing is perhaps not so fixed to a date, but it's simply this, that if you are in a state of mind as a nation that you cannot cope with the rule of law, then the threat of accountability becomes the more pertinent and the more focused. And that's a very real threat to any form of dictatorship, whether or not it's masquerading as a faux democracy or not. So that's another reason why accountability has to come now and fast. There probably aren't very many things that the Kremlin is frightened of, but I'm sure they're frightened of the rule of law.
I know that we're running out of time, but very short answer perhaps to one question. Recently, a couple of weeks ago, we've heard at Munich Security Conference, Vice President Kamala Harris putting at the center of her speech accountability for atrocities committed in Ukraine. And she was very vocal and specific, defining the crimes as crimes against humanity. To a lawyer, myself, it was music to my ears already to hear clear definition of a crime against humanity already being committed in terms of representative of the US government. We've been concentrated up until now mostly talking about the war crimes. Simply by the nature the war is ongoing, and it's just easier logically to switch to that perhaps as well. But do you see in your work and processes that you are coordinating, are engaged, that it's already coming up more profoundly, that it's not just war crimes cannot be just, but it's not war crimes only, but crimes against humanity, and already possibly legal minds are thinking how much crime of genocide could be at stake when we speak about the definition of what we see happening in Ukraine. Any one of you, if you would want to pick, please.
If I may, again, my prosecutorial mindset suggests me that we have to stick to facts and to proven evidence. While we may think that there is widespread systemic attack or attacks against civilian population, I would rather wait for the outcome of proper legal analysis and to analyze individual attacks against civilian population and check whether they are or can be perceived or documented as widespread systematic. Through this core intentional crime evidence database, actually, we will be able to make such a conclusion. And because in certain countries, evidence might be available concerning individual crimes. However, in those jurisdictions, it's not enough to conclude that these were widespread systematic. However, if we put all these pieces of evidence together, we may come to such a conclusion. So again, United for Justice, it might be also a motto for core intentional crime evidence database. Thank you.
Thanks to all of participants of this panel. You want to add something? We are critical right of time. I'm really sorry if you've been really short.
The mic is not. Not really.
Try one more time.
Now it works. It just has to be put down, and the shock makes things work. Works for many things, including for United for Justice, by the way. I think that accountability for international crimes will be a key issue in the coming months, including in the summit of heads of state of the Council of Europe, which will meet in Reykjavik in May this year. And I think that this is a moment of truth for not only Europe, but also the international community as a whole. Thank you.
Thank you very much. Thank you for not only being today with us at the panel discussion, but for all the work that you do, helping Ukraine, being part of the team that is United for Justice. And thank you for bearing with us after a long introductory session as well during this panel discussion. Thank you.
Thank you very much. We have one panel to go this evening, and before we will start the next panel, I have an important message for everyone. The information security rules of our conference have been softened. The ban of publishing is now in effect every day until the end of the main program. So this means that right now the ban on publishing